Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Responding to a Potential Privacy or Security Breach, Internal and External Strategies. Today's presenters are Alexander Naum and Heidi Kocher. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box and we will address as many as possible at the end of the presentation. So without further ado, I just present your speakers, Alex Naum and Heidi Kocher.
Thank you so much, Gio. And actually, let me just correct. Somehow there was a misprint on the schedule. We are actually not responding to security issues. What we're actually talking about today are data privacy and security issues and regulations, HIPAA and beyond. So I apologize for any misapprehensions about what the subject of today's webinar is. My name is Heidi Kocher. I am a partner at Lyles Parker. I've been doing healthcare law for 25 years or more, and really enjoy this field and have been doing webinars for TAHCH for many, many years. I'm based in Dallas, and Alex is based in Washington, D.C. And Alex, do you want to introduce yourself real quick for the audience?
Of course. Thank you, Heidi. Hello, I'm Alexander Naum. I'm Lyles Parker's privacy officer. I've been with the firm for nearing a year now. I have experience working at CMS, working for the American Health Law Association, and we're just very excited to discuss some important topics you should consider in your organization's data compliance program.
Absolutely. All right. Gio, next slide, please. So we have, of course, being lawyers, a little bit of a disclaimer. This outline is general information only. It does not constitute legal advice and should not be used as a substitute for seeking legal counsel. We are attorneys, but we are not your attorneys, and sometimes outcomes can differ depending on specific facts. Next slide, please.
In this webinar, we'll discuss why data compliance is important, including touching on the various complaints, incidents, and penalties organizations have faced because of failures in their data compliance program. We will additionally discuss other elements your organization should consider to have a successful compliance program, including the HIPAA security rule, how to act when a breach occurs, patient right of access, information blocking, data security in the age of social media, the future of HIPAA, and other data compliance tips. Next slide, please. So to begin, it's important to understand that as of October 31st of this past year, HHS OCR, Office of Civil Rights, received close to 345,000 complaints of privacy violations. I'll repeat, 345,000 complaints. Among that astonishing number of complaints, 67% of those were resolved with corrective action plans, and 33% were later determined not to be in violation. However, among the organizations who were in violation, 138 of the cases were settled with monetary fines, while 1,979 of the cases were referred to the DOJ for criminal prosecution because they involved the known disclosure of protected health information, also known as PHI. We're going to say PHI a lot, but just understand that that means protected health information. In the full calendar year of 2023, 546 incidents were reported to OCR involving the release of PHI affecting 500 plus patients. Some incidents in the tens to hundreds of thousands of patients affected. A majority of those incidents were a result of hacking or IT mishaps, while a little over 14% were a result of unauthorized disclosure or unauthorized access or disclosure, including unsecured network servers, accidental or misused email communication, or EMR. And we can go to the next slide, Gio. So I mentioned monetary fines in the last slide, but here's a breakdown of how those fines are assessed. I want to stress the importance of having a comprehensive data security program, allowing you to detect and respond to an incident as soon as possible. This program should also include conducting at least a yearly security risk assessment with all of your employees. Not only will it greatly prevent breaches or unauthorized disclosures, but evidence that an organization conducts a yearly security risk assessment has often served as a mitigating factor when determining fines and other penalties. As you can see by this breakdown, fines can range from the hundreds of dollars to the tens of thousands of dollars per incident, potentially totaling in the millions. The severity of these fines depend on how the incident occurred, how the organization responds to the incident, and other factors. And we can go to the next slide. So as I mentioned in the last slide, not only can your organization face monetary fines, but members of your organization have the potential to even face criminal penalties. These criminal penalties are determined by how the breach occurred or how you responded to the breach. Did you fully ignore it, or was your organization so neglectful that you should have known about the breach? Or was the breach a result of bad actions, including obtaining the PHI under false pretenses, disclosing the PHI for personal gain, which can also include selling PHI to data brokers? These criminal penalties can range from several months to up to 10 years in jail, depending on the severity of the action. And I'll hand it over to Heidi.
Thank you, Alex. So the foundation of all of these things, of course, is the HIPAA security rule. And I want to remind people that this was published in February of 2003. So that means the HIPAA security rule has been around for 20 years. I have talked to people and done presentations where we have audience members, and they have children who are now in college who were born after the publication of the security rule. So because this rule has been around for so long, OCR and the investigators really expect you to understand what your requirements are and that you have taken steps to meet those requirements under the HIPAA security rule. So just to recap, a covered entity has to maintain the confidentiality, integrity, and availability of all ePHI that they create, receive, maintain, or transmit. And those are 4 magic words. They appear over and over in the regs: create, receive, maintain, or transmit. You must take steps to identify and protect against reasonably anticipated threats to the security and integrity of the information. This is where the security risk analysis comes into play, as Alex mentioned. You have to protect against reasonably anticipated impermissible uses or disclosures. And finally, you have to secure insurance by the workforce, which means you have to be training them. And remember that HIPAA is a floor, not a ceiling. We in Texas have House Bill 300, which imposes additional requirements, and we have to meet those requirements. And HIPAA explicitly says that where there is a state law that provides greater protection, you must abide by the greater protection. So we've got that as well, and I'm not going to go into that in detail. Business associates also became independently liable for all of the requirements in the HIPAA security rule after HITECH passed and the rules for relative to HITECH were implemented in 2013. Next slide, please. As I said, a security risk assessment is mandatory. And people say to me a lot of times, oh, well, I don't take Medicare or I don't take a federally funded program. Well, the problem is that every insurance payer contract that I've seen also has a provision buried in it that you will comply with federal rules relating to the Medicare program, or they'll have something like you have an effective compliance program addressing Medicare regulations. And invariably, they also say something about you must protect our covered individuals' patient privacy, which is HIPAA. So even if you don't take private insurance, you are still responsible for, by contract, complying with the HIPAA rules. And for the security risk assessment, all I can say is just do it. Just do it. It will provide so much protection for you. As Alec mentioned, it is a mitigating factor in looking at any penalties, be they civil or criminal. So you really want to do it. And there's our self-help tools out there. I put a link up there. Let me just say that the self-help tools are not always the best. We have resources that can help you do a security risk assessment easily and relatively inexpensively. So there is no reason for not doing a HIPAA security risk assessment. The way I say this is, it's like mowing the lawn, right? If you live in a house and you have a lawn. Now, could I mow my own lawn? Absolutely. I could mow my own lawn. I can get my mower out and I can walk back and forth cutting the grass. Do I want to mow my own lawn is a separate question. And many of us will say something like, no, I don't really want to mow my own lawn. So I hire a lawn service to mow my lawn. Same thing with the pool. You could maintain your pool on your own. Do you really want to do that? Probably not. So we contract it out. Same thing with a security risk assessment. You can contract it out, but you can also do it by yourself if you so want. And so we have put in here a number of links to help you for conducting an SRA if you choose to do so on your own. And again, if you have a breach and OCR comes in and investigates, the very first question they will ask you is for a copy of your SRAs going back 6 years. I was actually at a client yesterday who had a breach, and OCR sent him the letter, and sure enough, OCR asked him for his SRA going back 6 years. Guess what? He's never done an SRA. So unfortunately, he is in a bad situation, but we are going to be doing an SRA for him. Well, we did an SRA for him yesterday, and this will get him at least some brownie points in his response to OCR. So again, just do an SRA if there's one thing you take away from this presentation. Next slide, please. One of the things that people always ask about is encryption. So the weird thing is that encryption technically is not required by the security rule. The problem is that technologically at this point, it is the only way to achieve security. We don't have any other way of securing the data other than encryption. So therefore, encryption is a must for all of your devices, especially those used in the field. And the nice thing is that if you have your devices encrypted, then your PHI, your ePHI, shouldn't be able to be accessed, which means if you can't access your PHI or ePHI improperly, then when you have a breach and you go through a 4-factor analysis, which we'll talk about in a little bit, if you go through that, then one of the questions is, was the PHI accessed? And if it's encrypted, you can say no, which then makes the rest of the analysis that much better for you. One of the things to remember is that approximately 1/3 of all the settlements and resolution agreements that OCR has entered into do involve the loss or theft of unencrypted devices. And again, this becomes a huge issue. There is guidance from OCR on how to make ePHI unusable, unreadable, or indecipherable. And NIST, the National Institutes for Standards and Technology, also has a guide to storage encryption technology for end user devices, which are things like iPads, cell phones, and laptops that you use out in the field. One thing to note, there are allegedly updates coming this summer for both the privacy and security rule. Again, these rules have not had major updates in quite some time, so stay tuned for that. Also, I think there will be changes due to the Change Healthcare breach, which I'll talk about at the end of the presentation. So again, make sure you've got your ducks nailed down in this regard. Next slide, please. So one of the issues that OCR has had a long time is about what we call PHI out in the wild, or lost or stolen ePHI. And there are some big cases out here. University of Rochester in 2019 had failed to encrypt laptops and flash drives, and they had been having losses in 2010, 2013, and 2017. And so as a result, that led to a $3 million settlement and a 2-year corrective action plan. North Memorial Healthcare back in 2016 also had a $1.5 million fine after an unencrypted laptop was stolen from an employee's car. But one of my favorite cases is the Lincare case, and this is from 2016. In this situation, as you may all know, Lincare is a provider of DME. And one of their regional managers had patient files in her car and her personal residence. And mind you, this dates back to the 2000s, when cloud-based systems really weren't as ubiquitous as they are now. So in any case, she had paper files in her car and on her laptop, and she was having marital issues. So in August of 2008, she moved out of her residence, and the husband stayed in the residence. In December, the husband notified OCR that he found patient files under a bed and in a kitchen drawer, and as a result, 278 patients' data was inappropriately disclosed to him. After an investigation, OCR found that Lincare did not have policies regarding safeguarding of PHI taken off the work premises, and Lincare paid almost $240,000 in fines. So again, some of this is not probably applicable to you all because, again, these were paper files and much is in the cloud right now. But you do need to know that, you know, people out in the field are a huge risk for all of you. And again, makes the importance of encryption that much more visible. Next slide, please. So just some other things to be aware of. HIPAA has had some recent resolution agreements with different kinds of breaches. We, of course, have the improper disposal of PHI. This is where a dermatology practice allowed empty specimen containers with PHI on the labels to be placed in the regular garbage bin in the parking lot. The practice is paying $300,000 in fines and a 2-year corrective action plan. iHealth Solutions was a business associate that provided coding and billing services. They had an unsecured server open to the internet, and as a result, a hacker exfiltrated data for 267 patients. They had failed to conduct, blah, blah, a security risk analysis. And so they paid $75,000 in fines and also signed a 2-year corrective action plan. Employee snooping is a big deal, and this is one of the cases that highlights the importance of training your staff on minimum necessary rules. The hospital security guards accessed the medical records of 419 patients, again, checking up on their neighbors and their friends and family and so on. The hospital paid $240,000 in fine and again signed a 2-year corrective action plan. And finally, another example is a breach by a hacker. A hacker installed malware on the Oklahoma State University server, and I'm just shocked by that one. You would think that a big university has systems in place to prevent that. But the most shocking thing is that the breach was undetected for almost 2 years. So again, they did not have the things in place. And they resulted in the disclosure of PHI for almost 280,000 patients. So OSU was fined for failing to conduct, you guessed it, a security risk analysis, for failing to implement a security incident reporting program, and failure to provide timely breach notification to patients. And as a result of this, OSU paid $875,000 in fines. Don't let this be you. Next slide, please. Excuse me. So along with the security rule, this works in tandem with the security rule, and this is the breach notification rule. The breach notification rule comes into play when you have an impermissible use or disclosure of EPHI. And the way the rule is written, that such impermissible use or disclosure is presumed to be a breach unless the covered entity or business associate shows a very low probability that PHI was compromised, and they apply a 4-factor test. And these 4 factors are the nature and extent of the PHI involved, including what kinds of identifiers were accessed and what is the likelihood of re-identification. Who is the unauthorized person who used the EPHI or to whom the disclosure was made? Whether the PHI was actually acquired or viewed. And this is where encryption comes into play, because if you encrypt your data, then you can't actually acquire EPHI or view it. So that's why encryption is so important on this factor. And then the extent to which the risk to the PHI has been mitigated. If it was paper records or a fax, did you get it back? Did you get some kind of confirmation that a misdirected fax was destroyed or shredded? So on and so on. Don't forget that under the breach notification rule, the time limit to notify patients is 60 days from when you know or should have known that a breach occurred. And we have seen numerous cases in the past where the covered entity attempted to say, oh, we were still in the forensic analysis portion of this. We didn't realize, we didn't know for sure that a breach had occurred. And so that's why we didn't notify the patients until we got the final report from our forensic IT people. Excuse me. Allergies today. Don't wait until you actually get to that point when you have a reasonable belief that PHI was breached. At that point, your 60-day clock starts ticking, and OCR is not very kind about that, as we will see on the next slide. So one of the things that OCR, next slide please, there we go. One of the things that, again, that OCR really takes pretty seriously is notification to patients. And so we've seen Presence Health in 2017 was fined $475,000 for a 42-day delay in reporting to OCR and sending out the notifications to patients. 42 days. That's basically a month and a half, 6 weeks. And they got hit with a pretty substantial fine. Don't be like Centara Health. In 2019, they paid over a $2 million fine. And the situation with Centara Health was there was an indication, I believe it was a patient complaint about a breach of PHI, and OCR came in and offered what OCR calls technical assistance. That's always the first step, where OCR says, okay, you're supposed to do A, B, C, D. So OCR came in, told them you need to be doing all of these things to comply with HIPAA, the security rule. And they dragged their feet and didn't do it. 6 months later, OCR came in again and said, okay, when we said you need to comply with the security risk analysis, with the security rule, that means you must conduct a security risk analysis. Centara Health, please go and conduct a security risk analysis. 6 months later, OCR came back, and Centara Health had still not done a security risk analysis, despite OCR explicitly and clearly telling them this is what you must do. So they got a pretty substantial fine for not doing an SRA. So again, the takeaways from this slide are: don't delay in doing what you need to do if you have a breach. And again, remember that a security risk analysis is so critical in not just doing it up front, but also in doing one in response to a breach. Next slide, please. One of the things you all should be aware about is that state attorneys general are also getting into the fray with data security and breach notifications. And they are discovering that this is a pretty fertile source. I'm going to mute for a moment because I need to clear my throat here. Took allergy meds this morning and it's still not working well. So, as I said earlier, remember that the HIPAA security rule is a floor, not a ceiling, and if you have state rules that might be in play, you need to comply with those as well, especially if the state rules provide more protections for the patients. So, in November of 2022, Aviana Healthcare actually experienced some phishing attacks. They had over 600 emails. And this was in July of 2019. The Home Health Agency discovered that some employee accounts had actually been hacked in August, and then they notified the affected patients in February of 2020. So again, August, September, October, November, December, January, February, 6 months after the discovery of the actual hack. So you had PHI of over 4,000 patients and employees exposed. And in this situation, the Massachusetts Attorney General stepped in and stated that their security program did not meet the requirements of the Massachusetts data security regulations. And as a result, Aviana, the Home Health Agency, paid a $425,000 settlement and was required to implement a quote-unquote comprehensive information security program. And mind you, this corrective action plan is 4 years long. So they're providing reports to the Massachusetts Attorney General for 4 years. I should also note that this breach also led to class action lawsuits by the affected patients. Another example is the Retrieval Masters Credit Bureau situation. Retrieval Masters did business as the American Medical Collection Agency, or AMCA, and what they did was they had a specialty of collecting small balance medical debt. Between August of 2018 and March 2019, they had a breach of their systems, and among other patients, other states' patients, discovered that 1.4 million Texans' data was exposed, and again, 7 million people total. Here we had 41 state attorneys general sue AMCA, and as a result of this, AMCA agreed to a 7-year corrective action plan implementing a security program, an information security program, and that included the hiring of a CISO, or a Chief Information Security Officer. And they also paid $2.8 million in fines as a result of this to resolve it. And finally, although this isn't specifically a healthcare incident, we had the Equifax breach about 1.5 years ago, 2 years ago. And again, Equifax had exposed the personal information of approximately 145 million Americans. That is about 40 or 45% of the population of the United States. So just a vast, vast number. And as a result, there was a nationwide $600 million settlement with Equifax, and Texas, the Texas Attorney General collected $10.9 million as a result. So again, it's not just the federal officials that are involved in this. You've got state level officials, and depending on the state, you could end up with things like class action lawsuits. HIPAA itself does not give an individual right to sue, but again, you can have rights to sue under state laws, so that's another thing to be worried about. Next slide, please. All right, we're going to change gears a little bit here and talk about the patient's right to restrict disclosure. Patients have the right to restrict the disclosure of their information, And where this often comes in is with family members. Long story short, it is okay to share information with family members if the patient doesn't object or explicitly agrees. So I know many of you, when you do your intake paperwork, you have a little section where who is it okay to share this data with, and then you collect that person's information as well. You can also assume that sharing information is okay if you are in the presence of the patient and the patient seems to indicate that the family member is to be included. So again, for example, if you're doing intake in a patient's home and you ask the patient a question and the patient, for example, turns and looks to their spouse and says, "Isn't that right, honey?" So there you have implicit agreement by the patient and non-objection. So you're okay to share information in those circumstances. I would probably note that the patient didn't object in your records just to cover yourselves. You do want to be aware of disclosures involving mental health. That is super tricky. And again, we have special rules and regulations dating with disclosures involving mental health, both on the state and the federal level. If the patient is incapacitated, the healthcare provider can share information with family members if, in his or her professional judgment, the provider thinks that the patient would not object, or if it is in the best interests of the patient. This typically comes into play in emergency room departments or situations, but it might also happen in the home, again, where you have a hospice patient who is nearing the end of life, and you really think that the patient wouldn't object and it's in the best interests. One thing to remember is that disclosure always has to be restricted to minimum necessary. So for example, and I'm going to use mental health here as an example, if the patient is on hospice for a kidney disease issue, chronic kidney disease, and they're passing away because of that, and you happen to know that they had mental health treatment, and that's in the records that you received, don't disclose that to the family members, again, unless there is some kind of explicit agreement by the patient. OCR has issued some specific guidance out there for providers, and we put the link here in the slide. And when you get the slides after the webinar, you'll be able to click on those hyperlinks and go directly to that resource. Next slide, please. So the flip side of the right to restrict disclosure is that the patient has the right to access their information. And HIPAA specifically permits patients to access their information. In fact, the federal regulation at 45 CFR 164.524 grants the patients the right to access information in what is called the designated record set. The designated record set is pretty much all of the medical records related to the patient. It doesn't include things like the quality control records that you might have, but it does include all of the medical records specific to the patient needed for treatment. So the patients always have the right to access their own information. And the personal representative of the patient also has the right to access PHI, and they also have the right to instruct any covered entity to transmit a copy of PHI to a designated person or entity. So most of the time people think that this applies to minor patients where the parent or the person in a parent's shoes directs the transmission of PHI. But this applies to adults as well. And again, if the patient designates somebody that has power and authority to access PHI, then that person may very well also have the ability to direct the transmission of PHI and to get a copy of it. So over the years, HIPAA has fielded a large number of complaints from patients about them not being able to access their PHI. And some of the case reports that we have looked at are actually quite astonishing. There is one case report where a patient tried for 2.5 years to gain access to her records, sending, I lost count of how many times she requested the records. And for one reason or another, the entity just never sent the information. So as a result, OCR entered into this Patient Right of Access initiative, and they have actually investigated and prosecuted a number of entities for failure to provide access to PHI on a timely basis. And as a result, as of the end of March, we have 47 entities that have now entered into resolution agreements and paid fines. And the resolution agreement, again, contains like a corrective action plan where they have to do various things. Let me just say that it is rare to see a project like this, and Alex can chime in on this as well, but we rarely see a large-scale project like this where a government agency goes out and deliberately kind of looks and prosecutes into these kinds of things. So the fact that you have 47 entities that have signed resolution agreements should make people sit up and take notice, because it means OCR is taking the patient right of access very, very, very seriously.
Absolutely.
Okay, next slide. Combined with all of this, as if this weren't enough, we now have new rules on what is called information blocking, and this is separate from the right of access. So the 21st Century Cures Act, which was passed in 2016, authorized the OIG to investigate and impose penalties for information blocking. So in May of 2020, the Office for the National Coordinator published rules defining information blocking and addressed what it is and how they are going to investigate it. They're using the term EPHI, which we should all know. It's Electronic Protected Health Information. Note that EPHI does not include psychotherapy notes or information that is compiled for use in civil, criminal, or administrative proceedings. But again, it is very much the core patient record. And information blocking is defined as a practice that is likely to interfere with the access, exchange, or use of EPHI, and the healthcare provider knows that such a practice is unreasonable and is likely to interfere with or prevent or materially discourage access, exchange, or use of EPHI. So this is an example here where a patient comes in and says, I'm seeing a new physician. I want you to send a copy of my medical record in the EMR to my new provider. Oh, it turns out that both of my providers on, let's just say, eClinicalWorks, and there are abilities in these EMRs to be able to transmit electronically the patient file, the patient record from one provider to another provider. So for whatever reason, the first provider does not send it. Common excuses are things that we hear like, oh, the formatting is slightly different, or oh, we couldn't match the patient, or something like that. Well, as a result, since the rules came into play, in basically the space of 3 years, OIG has received 939 claims of information blocking. That's essentially one a day, which again is a really high number. 62% of these complaints came from patients, and again, the OIG is busily investigating these and entering into agreements to resolve those issues. We should note that the information blocking rules do have a number of exceptions. One of them is an individualized assessment of the risk of harm by a licensed healthcare professional who has a clinician-patient relationship with the affected patient. So typically, this is the mental health type exception. And also, it defines as an exception the same type of harm as when a covered entity as a whole denies access to PHI, be it either electronic or paper-based. So if there's a reason that you're denying access to PHI, that same exception or that same reason applies to the denial of access to ePHI under the information blocking rules. Next slide, please. So we've had some new changes to them, and HHS and OIG are moving incrementally on developing regulations on this. So last year, they actually published a final rule imposing penalties on health IT companies for information blocking. In October, they published draft information blocking rules for certain healthcare providers. And currently, this is aimed at hospitals and MIPS eligible clinicians, and those are MDs, DOs, NPs, PAs, PTs, occupational therapists, and social workers, etc. Anybody who is eligible for a MIPS payment. So it's not just do you take a MIPS payment, but are you eligible for it? And so what they are looking at is, again, trying to encourage people to appropriately share information and not block electronic information from being shared. HHS specifically said that they will be expanding these to other providers and clinician types in the future. But as a result of these rules, a patient can now report potential blocking via the information blocking portal. They set up a specific portal. And the penalties, again, for anybody who does take MIPS is a denial of a meaningful use status. And if you are in an ACO or in a Medicare Shared Savings Program, you will be removed from that program. So there's a financial penalty on there. Penalties are going to be published on the Office of National Coordinator's website. This is very similar to OCR's so-called wall of shame, where breaches of the PHI of 500 or more individuals are published. So again, just remember that at this point, it doesn't apply to home health or hospice agencies. It may apply to your individual clinicians. So just be aware of that, and these are things that you should be looking into. Next slide, please. This is just a snip from OCR's website, kind of showing you again through March 31st how many submissions they received and how they fall out. One thing that I would note is there may be a use for the information blocking rules by entities such as home health care agencies or hospices. As you see on the bottom graphic, there are just over 100 of complaints coming from a healthcare provider. I think the information blocking rules in the right circumstances can be used by healthcare providers against other healthcare providers. So for example, if you have a patient and you have admitted them to service and they're under your service and you need updated records from the physician or the hospital and you are just not getting them, I think there is a possibility that you could file a complaint under the information blocking regs in an effort to dislodge getting those records. Because again, remember, if you've been trying to get these records and you've been unsuccessful, heretofore you've sort of been stuck. But with information blocking and filing a complaint, now what happens is the government is going to step in and investigate it, and in most situations will likely force the subject healthcare provider to share the information with the requesting provider. So I'm not saying use this in all circumstances, but if you have a circumstance where you're not getting required information that you need to do what you need to do to provide care to the patient or comply with data requirements for an ACO or something like that, think about whether or not the information blocking rules might be usable offensively to help you out in that situation. Next slide, please. And Alex, I think you're going to be taking over this piece.
Yes. So in this new age where social media dominates our daily lives, or at least the daily lives of your younger employees, it's important to factor this into your compliance program. For example, CMS published a memo on long-term care staff use of social media, especially photographs, which we attached a link to this slide. Key things your organization should consider. Make sure you have a policy in place over the use of social media in the workplace and have your staff sign an acknowledgement form. If photographing, obtain patient consent. Limit distribution and use to as minimum as necessary. Any posting involving personally identifiable information requires patient authorization. HIPAA applies not only to personal social media accounts, but also corporate ones. Therefore, monitor all of your channels. You can do this by setting alerts whenever your entity name is used or hashtags are mentioned. And finally, beware of responding to online reviews, especially negative ones, which we will get into an example in a couple of slides. But we'll go to the next slide. More considerations regarding social media use for nurses specifically, but also applicable to other industries interacting with PHI. This includes never transmit individually identifiable patient information, understand that social media posts can be viewed by the public as a whole, take advantage of privacy settings on your electronic devices, and seek to separate personal and professional information online. That's definitely very, very key. Bring content that could harm a patient's privacy rights or welfare to the attention of appropriate authorities, and participate in developing institutional policies governing online contacts. And go to the next slide. So here
actually,
are some of the...
let me just jump in here really quick. Let's go back to this slide. I want to tell people, so these are, again, American Nursing Association ethics rules, which means they are not law. The Texas Nursing Board of Nurse Examiners does not explicitly incorporate these principles into the standards for nurses in Texas. However, they are evidence of the standard of care in the community and the nation as a whole. So even though you are not explicitly held to these ethical rules, in many states they are, and certainly in Texas they become evidence of what nurses should and should not be doing. So you need to keep these in mind and not just kind of go, oh, well, this doesn't necessarily apply to us.
Definitely. Thank you, Heidi. So moving on to some bad examples. In recent years, OCR has ramped up enforcement regarding social media use. In 2016, a sensitive image of an Alzheimer's patient was posted on the social media app Snapchat. Even though the image was only up for 24 hours, the offender was sentenced to 30 days in jail. In 2022, after responding to an online review that involved the disclosure of PHI, a practice had to pay $23,000 in a settlement, and the offender had to separately pay $50,000 in a civil monetary penalty. In this past year, a psychiatry practice paid $30,000 in fines and entered into a 2-year corrective action plan after responding to a negative Google review and disclosing the patient's PHI. All this is displaying the importance of factoring in social media use into your data compliance program. Can we move on to the next slide? So we are nearing 30 years of HIPAA. And in those 30 years, technology and the internet has greatly expanded. To respond to the changing times, the government has changed how HIPAA is enforced, including enacting the privacy rule in 2000, the security rule in 2003, and the high-tech regs in 2013. More recently, OCR proposed a new rule in 2021 that will likely be published later this year. The proposed language would expressly permit covered entities to disclose PHI in home and community-based service providers to disclose PHI to home and community-based service providers that provide or coordinate health-related services that are needed for care coordination and case management. The proposed language expressly permitting individuals to direct sharing of their ePHI among providers to help coordinate care. This would eliminate the need to obtain patient acknowledgement of receipt of the notice of privacy practices. And again, this is not a rule yet, but definitely be on the lookout for this rule being published. So this is another really big issue. As technology continues to advance, bad actors, including foreign and domestic hacking organizations, have expanded their operations and begun targeting healthcare data infrastructure. Among these hacking incidents include what is known as ransomware, which occurs when a hacking group gains access to a system, encrypts, and locks valuable data. That can include patient records, patient billing information, and other PHI. But it can also include broader organizational data, potentially blocking the ability for an organization to conduct business altogether. According to the FBI, the healthcare industry is the biggest target of these attacks, with 249 reported complaints in 2023 alone. Now, I want to put an emphasis on the word reported because there are many organizations who neglect to report these types of breaches and choose to cooperate with these illegal organizations. If your organization experiences a ransomware attack, understand that time is of the essence. Failure to respond promptly and properly can result in the permanent loss of data or access to your systems and the misuse of protected data. No matter what these organizations are threatening, do not pay the ransom. I repeat, do not pay the ransom. Law enforcement can view this act as funding criminal activities or even a violation of the Office of Foreign Assets Control's regulations against engaging in transactions with sanctioned foreign entities. Think like a lot of these entities are from sanctioned foreign countries. Additionally, there is no guarantee that you can regain access to your data and the systems following the attack. Even if they do regrant access, your organization may be categorized as a cooperative source of revenue, encouraging future attacks from these organizations. The best course of action following a ransomware attack is to secure all unaffected systems, including employee personal devices, and seek support from legal counsel as soon as possible. And Heidi can discuss a really big recent ransomware attack.
Yeah, so what Alex said on the prior slide really comes into focus with the Change Healthcare breach. I presume you all know what happened, but let me summarize really quickly. So Change Healthcare is a clearinghouse. It is owned by Optum, which in turn is owned by United Healthcare. And February 21st, Change went down initially because they thought something was going wrong, and then they went down due to the ransomware. Again, Change is one of the largest sets of clearinghouses in the nation, or the largest clearinghouse in the nation. They have actually subsets for different kinds of providers. So for example, the majority of Change's pharmacy claims infrastructure went down, which touched virtually every pharmacy in the United States. We have since found out that the hackers had actually been in their systems since at least February 12th. And this is important because this is a very common pattern where hackers gain access to your system and then they don't do stuff right away. They actually sit there quietly, unobtrusively, and they scope out the rest of your network. They look at where access are, what other access they might have, what they are able to do. And this is all in the background. And once they have gathered that information, then they execute the ransomware. So as part of the Change Healthcare breach, allegedly 6 terabytes of data was exfiltrated. I cannot even begin to tell you how much 6 terabytes of data is. It's a lot of data. Change touched somewhere between 1/3 to 1/2 of all the claims in the United States. So, conservatively, we have well upwards. There's about 330 million population in the U.S. I think it's 330, 336, something like that. So well over 110 million patients have had data exfiltrated. They also exfiltrated a lot of company-specific data. The reporting is that they got access to contracts and key financial data. United Healthcare, the parent company, eventually decided to pay $22 million in ransom. The problem is that these hackers are not just one individual or one group. This kind of stuff is actually a business, and the main hacker will subcontract out various aspects of a hack to other criminals. So, for example, somebody will write software to gain access to a system. Another individual or group will write software to exfiltrate data, and another group will actually write software to encrypt the system. So as a result of this, even though Change paid $22 million in ransom, there was a second group that popped up, and again, nobody is really sure if this is just the original hackers who put another mask on or if this is a subcontractor, but they complained that the original hacking group, which is known as Alpha V or Black Cat, they complained that Black Cat never paid them their cut for the services they provided. And they came back to United and said, pay us another ransom or we're going to disclose 4 terabytes of data that we are holding. United essentially told them, go pound sand and no. If your contractor didn't pay you, you need to take it up with them, but not to us. Well, as a result, the second hacking group began to disclose data on the dark web, and it is still unclear exactly what is going to happen. There is still a lot of back and forth about this. Most but not all of United's or Change's systems are back online, and United actually has a specific web page set up for this, and I put the link here. Next slide. So Change is still an ongoing situation. What we do know is that virtually every hospital in the United States has had a financial impact. People can't submit claims. If they do get a payment, they can't get electronic remittance advices, and so on and so on. 74% of the hospitals in the U.S. have actually had an impact on direct patient care because they can't access patient records. And again, virtually every pharmacy in the United States was affected. Change says that 1 in 3 United States patients' claims were touched. Again, I've seen reporting that says it's higher than that it's 1 in 2. So far, United has lost $872 million, and the guesstimate is that they are going to have a $1.6 billion total loss as a result of this. One of the things that was interesting about this is when Change knew the hack was happening, there was a pretty good indication that patient data was affected. So you remember I said earlier that the standard was when you should have known that the hack happened. Change has actually not formally notified OCR yet of the hack, which is really problematic. But OCR didn't wait for them. They actually opened an investigation on March 13th. And as a matter of fact, there is a congressional hearing taking place today on the circumstances of the Change Healthcare. I would expect to see legislation coming out of this, and most definitely changes to the HIPAA regulations, both privacy and security. We had mentioned earlier that there were proposed regs coming out in summer. I'm thinking that those will still be issued in summer, and that there will be new regs coming out as a result of change. I don't think they're going to hold on to the summer regs, but it is a possibility. We have threats of new legislation, and of course, I read that there are at least 4 class action lawsuits that have already been filed against change. So the topic, or the way that I summarized the change healthcare breach way back when, and I stand by it today, is this one is going to leave a mark. Next slide.
Yeah, it's really, really wild, the whole change situation. But kind of continuing our conversation, we did briefly talk about, I mean, Heidi mentioned it many times, that, that there also are state-specific health privacy laws that you do need to incorporate into your compliance program. In this slide, we attached a resource to help aid your organization in learning the laws within your state or states of business. This resource is an interactive map where you can click any state and then be provided with a list of various privacy laws within that state under the section Topics Comprehensively Reviewed and the subsections Health Information Technology and Privacy and Confidentiality. It's important to note that this tool should not be used as a substitute for legal aid, nor should it be used as a comprehensive source when creating your data compliance program. And we can go to the next slide. And here is really just a visual of what we've been saying throughout this entire presentation. HIPAA is the floor, state health data privacy laws are the ceiling. They could only add more on top of the federal rules, which Heidi will now discuss the Texas-specific state rules regarding data privacy.
Yeah, and I'm going to go through some of these very quickly. Just be aware that in Texas, we have Chapter 181 of the Health and Safety Code, which is the Medical Records Privacy Act. It parallels the HIPAA rules, but some of the differences are that new employees have to be trained on PHI protections within 90 days of employment. By the way, this is the codification of House Bill 300, which was passed a number of years ago. Patients are also to be given access to their ePHI within 15 days of request. And the Texas Attorney General, as a result, created a standard patient authorization form. If anybody wants the link to that, we'll be happy to provide it. They upped the penalties for violations, and the numbers are here. And the Texas Medical Records Privacy Act also explicitly allows an individual to be excluded or to have licensing action taken for a violation of these requirements. So just be aware that this is, again, in addition to state laws and is more stringent than, in addition to the federal laws, and is more stringent than the federal laws. Next slide, please. We also have the Texas Identity Theft Enforcement and Protection Act. This is not limited to PHI, but includes quote-unquote sensitive personal information. So this might include like the credit card information if you're keeping that on file, or if you're using something like a health app with your patients. People come in nowadays and they download things from their Apple Watch or so on. That covers this, and it includes identifying information beyond PHI. This statute requires that you provide notice to the Attorney General within 30 days of a breach if 200 or 50 more individuals are affected. So again, this is a smaller number than under the federal HIPAA laws, and affected individuals must be notified within 60 days. Next slide. Don't forget also that we have the Federal Trade Commission's red flag rules on identification of identity theft. Those are in play right now, and we have seen occasions where the feds have used those. And finally, don't forget that state laws on data privacy go beyond just the state medical records law. There's a couple of them here. Last year, Texas passed the Data Privacy and Security Act, which will be effective July 1st, and it applies to all businesses conducting business in the state. There is an exemption for small business, which when you look at it and do the math for home health agencies, a small business is defined as an agency that has less than $19 million in revenues. So Texas is the 11th state to pass such a law. It includes sensitive data, which includes a racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexuality, citizenship or immigration status, or genetic or biometric data, children's data, and precise geolocation data. And under this law, consumers actually have the right to access, correct, delete, and obtain a copy of their data, and to opt out of the selling of personal data or sharing of personal data for targeted advertising. As said, if you're a small business, you are exempted, but this is a trend that we are seeing across the country with these kinds of rules being passed. Next slide, and we are about to wrap up here. I know we're a few minutes over. So you really need to know what your data privacy and security requirements are. Remember, we have the federal requirements and we have state level requirements. You should assign a person whose job it is to understand privacy and security. You can have a chief privacy officer if your organization is large enough. You can also have a chief information security. Make sure that your policies are up to date and also that you have the correct policies. Again, different statutes require different policies. Again, the one thing that I said, if you take one thing away from this webinar, make sure you conduct a security risk analysis periodically. The recommendation is annually, and if you have any major changes in environment or if you have a breach, you must do one afterwards. You have to train your staff. New employees must be trained within 90 days of hire, and others we recommend training on an annual basis. Be ready for a breach. Really, the situation nowadays in the environment is that there are two kinds of healthcare providers. Those who have had a breach and know it, and those who have had a breach and don't know it. The likelihood is that you have had some kind of a breach and you simply don't know it yet. So you want to have individuals designated who can take point on a breach, and you want to have a toolkit ready and available for responding. You want to monitor your social media, and very important, you want to purchase cyber liability insurance and make sure that the coverage is sufficient. I was at a client yesterday, and he has cyber liability insurance, thank you, and we're dealing with a breach for him. And thank God he has it, because I'm telling you, otherwise he is spending probably between $50,000 and $100,000 easily in responding to the breach that he had. And finally, if you are not getting data from another healthcare provider, consider if you can use the information blocking rules to your advantage. Next slide, please.
And most important, if in doubt,
ask.
Definitely ask. Yeah.
We will do our best to help you and answer questions, but this is really a circumstance where, sometimes they say, oh, the best route is to ask for forgiveness rather than permission. You don't want to be asking for forgiveness in these circumstances. All right, we are done. Gio, I think we have time for a few questions, if there are any.
Yeah, no, they're not questions related to the PowerPoint. So I'll just end it here with, so that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Alex, Naum, and Heidi Kocher. Everyone from today's webinar will receive a copy of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to Lyles Parker or to the emails and phone numbers up above. And have a good Wednesday. Take care.
Thank you so much,
Thank you all.
everyone.
Bye-bye.